court rise?
In the Court of Appeal Criminal Division, the Queen against Gordon Park, this is a reference by the Criminal Cases Review Commission under Section 9 of the Criminal Appeal Act 1995. The appellant Saul is present.
May it please the Court?
Yes.
I appear this morning with my learned friend, Mr. David Emanuel. The Crown is represented by Mr. Richard Whittam with Miss Louise Oakley, as the Court is aware.
Yes.
The Court obviously will be familiar with the facts of this case. The Court has an abundance of written material. With the Court's approval, however, it is my proposal to provide, by way of introduction to the case, a very brief summary of the relevant facts, within which we then propose to develop the grounds of appeal. I appreciate that in doing so, I will probably be covering territory with which the Court is already familiar, but in my submission there is some public interest in just setting out in brief terms exactly what this case is all about.
Yes.
My lady, the facts of this case can be summarised in this way. On the 17th of July 1976, the appellant Gordon Park, his wife Carol, went missing from the Hanley home in Lees, which is near Barrow-in-Furness, which is approximately 18 miles south of Lake Coniston in the Lake District. 21 years later, in August 1997, her body was found by amateur divers. It had been tied up in a fetal position with a number of ropes, and we have the images of that, the reconstructed images of that, in the Court's bundles. The appellant was arrested on suspicion of murder and interviewed at some length in 1997, and he was then charged and remanded in custody for a little under 2 weeks before his release. In January 1998, the Crown Prosecution Service discontinued the prosecution following advice from leading counsel, who identified a number of evidential difficulties with the Crown's case. And the Court has, as part of the bundle, the advice that he provided, as Mr. Price. On the 12th of September 2000, Channel 4 broadcast a documentary called A Very British Murder, The Ladies in the Lake, concerning 3 cases in which bodies of women had been recovered from lakes in the Lake District. One of those cases, of course, was the case of Carol Park. And during that programme, Dr. Tapp, who was the pathologist who'd examined the deceased remains, was interviewed. And he stated that an axe, or heavy, sharp instrument, like an axe, had been used to, as he put it, smash in her face. Following the broadcast of that programme, a man called Michael Wainwright came forward and told police that he'd been in custody with the appellant when he had been remanded, and that the appellant had confessed to him that he'd killed his wife. He said that the appellant had told him that he'd put his hands around his wife's neck until she passed out, and then he had hit her with a rock climber's axe. He had then taken her in his car to his boat and, in his words, put her down. Wainwright said that before speaking to the appellant, he'd been told by another prisoner called Glenn Banks, who he referred to as Banksy, that the appellant had been speaking about the Lake murder in his sleep. The police traced and interviewed Mr. Banks, who was, it was agreed at trial, a suggestible and vulnerable man, who also said that the appellant had confessed to him, but in terms which it was accepted at trial, in important respects, could not be true. At trial, the appellant denied that he had confessed to either Mr. Wainwright or Mr. Banks, and indeed called his solicitor to confirm that he had been advised not to speak to anyone in prison about his case. In December 2003, new prosecution counsel advised that the appellant be prosecuted on the basis of The cell confession evidence, Mr. Banks and Mr. Wainwright, together with the opinion of an expert in knots, a man called Michael Lucas, whose evidence was eventually abandoned because there were issues about his credibility and was substituted by a different expert called Roger Ide. That evidence, together with the circumstantial case, which had previously been identified, was sufficient to justify a charge. And at trial, the prosecution relied, in support of Mr. Wainwright's credibility, on the fact that an ice axe had been found at the appellant's home address. By the time of his arrest in 1997, he'd moved. He had been living at an address called Bluestones in Lees, and he left there in 1991. In the months leading up to trial, the prosecution obtained expert geological evidence to the effect that a rock recovered from the lake bed and used, it was suggested, to weigh down items of Carol Parr's clothing had an unusual feature which was identical to rocks recovered from the appellant's home address in Lees, but not found in rocks recovered from the lakeshore in the vicinity of where the body had been found. In 2008, following his conviction in 2005, the appellant applied for leave to appeal on the basis of new expert evidence, which in effect destroyed the prosecution case concerning the recovered rock. Leave was refused on the basis that the Court of Appeal doubted the significance of the geology evidence and that there was a strong circumstantial case in any event against the appellant. In January 2010, the appellant committed suicide on his 66th birthday. The case, as the court knows, now comes before this court as the result of a reference by the Criminal Cases Review Commission. One of the reasons for the reference was new DNA evidence emanating from an area of the rope used to bind the deceased. Following further examination, that ground of appeal is not pursued. The court has previously been informed about that at a directions hearing on the 3rd of October, and the court approved of the decision not to pursue that. I have to mention that because, of course, that is one of the reasons before the court within the CCR's statement of reasons. But in effect, the court at a previous hearing has accepted that that ground of appeal was properly abandoned. The basis on which the conviction is now said to be unsafe arises from allegations of non-disclosure by the prosecution at trial of matters relating to the witness Wainwright's credibility and to the pathologist Dr. Tapp's opinion as to the unlikelihood of the ice axe being used to cause the injuries to the deceased's face. The respondent accepts that that material should have been disclosed, but has provided no explanation for the non-disclosure other than to suggest that there was no bad faith. It is submitted, however, that it's difficult to avoid the conclusion, in the absence of any explanation, that there was possibly an element of bad faith in the decisions not to disclose the evidence, and more importantly, that the non-disclosure is directly relevant to the safety of the conviction. In addition, very late in the day, there is now new expert evidence from two forensic dentists which undermines Dr. Tapp's opinion, we submit, that a sharp-edged implement such as an axe was used to cause the injuries to the deceased, which is relevant in turn to the question of whether the appellant's ice axe was the murder weapon. That's what I say by way of introduction to the grounds of appeal. Can I, before proceeding further, just deal with the procedure before this court now?
Yes.
We asked the court to receive the new expert evidence. That's the expert evidence of the two odontologists and the expert evidence of Dr. Kolar. None of these witnesses are here at court. Both the appellant and the respondent agree, subject of course to the court's approval, that it will not be necessary for any live evidence to be heard and that the court can consider that evidence on the face of the papers. The court will have to make a decision as to whether or not to receive the evidence, and if received, what weight it should be given. But it's our submission that nothing is going to be usefully achieved by calling any of those witnesses. The dentists agree, the odontologists agree about the new evidence, which I shall come to in due course. And in the light of their opinion, of course, the opinions of Dr. Fegan Earle, who is the pathologist instructed by the Crown for the purpose of this appeal, and Dr. Kolar, who is instructed to respond to Dr. Fegan Earle, have clearly had to be substantially qualified in the light of the evidence from the expert dentists. And I just simply remind the court that it was as a result of Dr. Kolar's recommendation that the odontologists were instructed, and the court approved that course, agreed that it was important to obtain that evidence. That's now been done, and there is no disagreement about the impact of that evidence, if I can put it like that.
One element of the appeal grounds which raises an issue on disclosure, because you mentioned that the issue of the Crown accepted that certain matters should have been disclosed.
Yes.
But that doesn't extend to the convictions of
No, it doesn't.
Michael Wainwright.
No, I shall come to that. I shall come to that. The Crown accepts that I'll come to the particular points, but the Crown accepts that the material which showed that at the time that he made his second statement in June of 2004, that Mr. Wainwright was withdrawing from heroin should have been disclosed. They do not accept that evidence that he was arrested in January 2005 for offences of supplying amphetamines and cannabis should have been disclosed. They do accept, and this is perhaps the most important point, that the evidence relating to Dr. Tapp's opinion about the likelihood or unlikelihood of the ice axe having been used should have been disclosed. What I propose to do in a few moments is to just develop the first paragraphs of the perfected grounds of appeal, which deal with the factual context and the question of the strength of the circumstantial case, because that is obviously relevant. But before I do that, I wish very briefly to refer to the legal test, and I do this briefly. The court has submissions about the appropriate legal test. We have referred the court to the decision in Pendleton, and I hope the court doesn't think it was inappropriate or impertinent for me to provide an article from the Criminal Law Review, which is at the back of the bundle, which perhaps helps to develop those submissions. Our submission is that this is a case of some difficulty, and therefore the court should remind itself that it is determining the safety of the conviction as opposed to the guilt of the appellant, that there are a number of different factors in this case, and that in those circumstances it would be appropriate to consider whether or not, had the new material been available, it might have led the jury to return a different verdict.
This is very well trodden ground.
It is very well trodden ground. May I make it plain, because I really want to get this out of the way if I can. May I make it plain that it is our submission that however one looks at it, the material which is now available should lead this court to come to the conclusion that this conviction is unsafe. In every case, the court has to decide that and only that. That's the statutory test. But this is a case, if you like, a circumstantial case where it's very difficult to tell exactly what it was that influenced the jury in their decision. It might have been, for example, that the appellant admitted that he'd lied when he gave evidence in the childcare proceedings. Might have been a number of other factors in the case. We simply don't know. That is inevitably the problem or the nature of circumstantial evidence cases.
Mr. Blaxland, we have certain parts of the evidence that was presented at trial, the evidence of Michael Wainwright.
Yes.
We have the summing up.
Did.
We do not have a transcript of the evidence of the appellant
No.
or his cross-examination or of the closing speech made on his behalf.
No, it's true. That's right. And there appears to be, I've seen a note of part of Mr. Park's evidence at trial. There doesn't appear to be a complete transcript of it, certainly in the papers with which I've been provided.
It does seem rather curious when one of the issues we have to consider is the evidence presented at trial.
Yes.
And the strength of that case, or not.
Yes. No, it's unfortunate that we don't have it.
I don't want to interrupt, but
No, please do.
we made inquiries of any tapes or any recordings of the proceedings, and there are none, or certainly none that still exist. So we understood there's that lacuna that you quite rightly have identified. It's not a very helpful answer, but that's the answer I can give.
Thank you very much.
I mean, well, the court does, of course, have a note of Mr. Webster's closing address.
Yes.
And so the court understands what the... Can I start, but in terms of the addressing the court about the actual context, by going, and I don't necessarily ask the court to turn this up, but it's a short passage. I'm going to paragraph 23 of the statement of reasons. The reason for doing it is that the Commission appositely summarises the prosecution's case as follows. The prosecution case was founded on the original circumstantial evidence, a potential motive, a suspicious delay in reporting the disappearance, access to a boat, familiarity with Coniston Water, and expertise as a sailor and climber, supported by expert knot and geology evidence, evidence of Gordon Park's admissions in prison, 2 new witnesses' evidence of seeing a package being deposited from a boat in Coniston Water in late July 1976, and the proposition that Gordon Park had had told lies. It may be helpful if I go straight away then to the decision of the Court of Appeal in 2008, which is at tab 7, which is volume 2 of the bundles before the court. Because this, apart from anything else, is going to be relevant to the question of the approach which the court takes to the ground of appeal concerning the geology evidence. At paragraph 4, the court summarised the basic facts of the case and noted in the last 3 sentences this: the deceased had suffered a fractured jaw, an injury to one of her fingers, discoloration of the skull, and 2 fractured front teeth, consistent with the teeth having been struck with a blunt instrument, possibly an ice pick. An ice axe was one of the items found at the appellant's home. At trial, it was formally admitted that Mrs. Park's facial injuries had probably been caused by an axe. Now, in fact...
It's not accurate.
It's not accurate, no. The formal admission was that that was what was reported. But nonetheless, that's something which the court clearly considered to be sufficiently significant to include in its summary of the case. And then at paragraph 25, the court, in giving its reasons for refusing the application to leave, summarised what it considered to be the strong circumstantial case. So this is at page 375 of the bundle. And in the second sentence, the court says, we've already referred to many of these features of the evidence already. They include motive, arising from the established evidence of past marital disharmony, the applicant's knowledge of knots, his ability as a sailor and access to a boat, very necessary given the location of the body some distance from the shore, his knowledge of Coniston Water, including that part of it directly opposite where the body was found, his lies, some of which were not in dispute. I paused there. I think the only lie that was accepted was the lie to the court. The evidence of a man with some similarities to the applicant seen in a white boat, the same colour as his dinghy, pushing a large bundle over the side of the boat in late July 1976. The eastern side of Coniston, and of considerable significance, the court thought, the clothes found on the body, plus the lack of disturbance at the home. An intruder was highly unlikely, given the fact that there was said by the applicant to be no blood at the house, no disturbance and no signs of forced entry, that she was wearing a nightie and that her murderer had had access to her pinafore dress that he used to wrap the body. Since she was still in her nightie, it was also very unlikely that she'd gone off from the house voluntarily with someone, especially leaving behind her rings, purse and handbag. Now, it's quite clear from that the court attached very considerable significance to the fact that the deceased's body was found wearing a nightie. It is our submission that that was to overstate the importance of that evidence. And what was not considered, which in our submission is relevant, and was considered to be relevant by counsel who originally considered the circumstantial difficulties with the case, was this, that if the Crown's case, well, the Crown's case was, given that she was wearing her nightie, that she was killed at home. That would mean that she would be killed in her own bedroom, the parents' bedroom. We've included in the bundle a floor plan of the house and some pictures of the bungalow. It's not a big house. And the children's bedrooms were immediately adjacent to the bedroom, the parents' bedroom. There was part of the pathologist's evidence is that there were injuries to the hand, which were consistent with defence injuries. Dr. Kolar has opined that they might in fact be consistent with a punch, but in any event, it's consistent with her being conscious at the moment that she was attacked.
Fractured wrist and fractured bone in the hand.
Yeah, precisely, fighting back. There is therefore likely to have been a lot of noise. She's likely to have screamed. If this had been carefully planned in the way suggested by the Crown, it is, we put it as high as this, highly unlikely in our submission that he would have killed her in the way which the prosecution had to suggest, relying upon the nightie. The risks of the children waking up and being disturbed and coming across what was happening were enormous. Not only that, if it's correct that the injuries to the face were inflicted at the same time, there would have been a very great deal of blood to have been cleared up. The pathologist's evidence was also to this effect, that given the way in which he was tied up, that would have to have been done within the maximum 4 hours of death. The tying up was an elaborate procedure. There were a lot of ropes which were used. She was also wrapped up in a pinafore dress, her own dress, which was, again, that had to be sewn at some point and put around her body. It was then suggested that having killed her and trussed her up, he then concealed her in a freezer, a chest freezer, which was kept in the garage, and he would then have had to have taken her some 12 days later to Lake Coniston and disposed of her. Now, the reason that I make this point is this, that the single focus on the nightie in our respectful submission does not lead to the conclusion, or should not lead to the conclusion, that she was killed at home. If she had gone off with somebody else, which must be the alternative, because we accept that it cannot sensibly be suggested that there was an intruder who came in and killed her on the spot, given the amount of that would have needed to be cleared up at the time. She must have left with somebody else. And of course, if she left with somebody else, another man, then she's likely to have taken her nightie with her. And all it means, of course, is that she was killed while she was in bed or in a bedroom. That's the only inference which can safely be arrived at by reference to the wearing of the nightie. So that element of the circumstantial case is one which, in our submission, can properly be considered by this court when considering whether or not this was an overwhelming circumstantial case or a very strong circumstantial case, which was the opinion of the Court of Appeal on the last occasion and was certainly the way in which the Crown put the case at trial. The other elements of the case which do need to be considered are these. Alongside the body, or in the vicinity of the body, there was found a number of items of clothing which the Crown at trial said must have been Carol Park's because they were dated from that period, from the early to mid-1970s. My lady, we have in file 3 the statement from the expert who was called in relation to this, Pauline Rushton. And indeed, the court was supplied with copies of a schedule which set out all of the items of clothing. It's tab 29 in volume 3. And page 802 in the bundle, the second page of the statement, we see the items which the expert was asked to consider. It starts with a woman's blouse. There's then some knickers, a pair of homemade trousers, a machine-knitted acrylic tank top, a bikini top, a woman's mini dress, woman's knickers, a skirt, another pair of knickers, bra. Over the page, brown leather glove. And then there are a total of 11 items of footwear which were found. There are then, there's a pendant necklace, this is page 806, a long necklace, 4 necklaces, 5 necklaces, a bangle, bead, another necklace, so a number of different items of jewellery. And then we have also over the page some cosmetics. Now, when Gordon Park reported his wife missing in early September 1976, he was asked about whether or not, about the question of clothing. And one gets this from the summing up, which refers to the missing persons form.
Mr. Blaxland, do you have a copy of the frontispiece that was used at trial?
The frontispiece?
Of the missing persons form?
I don't.
Does the Crown have it?
I'm aware
I
of it.
don't. Can I just take, my lord may well be onto this point already, but can I just take the court to the section of the summing up which deals with this? It's at page 144. I mean, just to remind my lord and the court, of course, one of the issues which was raised at trial was the fact that the entire file which was created when she originally went missing in 1976 was lost. That formed the basis of an abuse of process submission, which was rejected.
All they had was the MISPA
Page
report.
144, bottom right.
All they had was the MISPA report, wasn't
That's
it?
right,
Yeah.
yeah. No, I've not seen it, no. So the court must have had it, I think, because there's reference to it at paragraph E. Missing, as far as the missing person form was concerned, he said he was unaware that Carol had received psychiatric treatment. Not come up, so there's a reference to the fact she was, he wasn't aware that she'd been taking antidepressants. And he was asked about the sections of the form dealing with clothing and jewellery. He said he had become aware of gaps in the wardrobe before he caused the report to be made to the police, but he had no idea what had gone. In retrospect, he now thinks, he said, that she took with her a heart-shaped locket, but he'd not been aware of that at the time. The point that we make is this, that if he himself had disposed of all of these items of clothing, he would have mentioned that. When he reported her missing, he would have said, she's gone, and what's more, I've been through the wardrobe, and I've noticed that there were a number of dresses which have gone missing. A pinafore dress, for example, that's gone missing. Appears that quite a
Do you
lot
think
of
he would
makeup
have
is gone.
had a detailed understanding of his wife's wardrobe? Is that the
Well,
point
if
you're
he
making?
disposed of the items, this is the point, if he himself, when he disposed of the body, had also disposed of all of these various different items, which must be the Crown's case, then he would have made a point, would he not, of informing the police about this when he originally reported her missing. And not only that, it's our submission that it's difficult, unless he wanted to make a particular point about her having taken all of these clothes, which he couldn't find, unless he wanted to make a particular point about that, it's difficult to see why he would have thrown away this rather random collection of different items which were found at the bottom of the lake. What we do accept is the Crown's case at trial, which is that it is highly likely that all of those items were in fact Carol Park's. It would be a very strange coincidence if, not too far from where the body was found, these items of clothing which date from the same period were not hers. So it's our submission that that's another feature of this case which tends to point away from him having committed the crime. Can I then turn to our submissions in relation to the significance of the evidence from the witnesses, Mr. and Mrs. Young, who said that they saw a boat on the lake, a white boat, and they saw a man who was described by Mrs. Young in particular, whose description clearly bore a resemblance to the appellant, tipping a package over the edge of the boat. The suggested boat that was used by the appellant was a sailing dinghy, a 505. And at trial, a copy of the 505, or a 505, not that one, was inserted in the jury bundle. And without asking the court to turn it up, the court can see it and will have seen it for itself. It's a very lightweight boat. It would, in our respectful submission, have been unstable if it was being operated by one person with such a heavy package on board. The description of the boat that was provided by the Youngs was a boat with a cabin. Well, that would have excluded the 505 from consideration. Much was made at trial of the appellant's evidence that he had sold the 505 in, he thought, June of 1976, which of course would mean that he didn't have it in his possession in July. And his sailing log, which he himself provided to the police, was put before the court. And can I ask the court to turn to that? It's at tab 30, volume 3, tab 30. Yes, and the boat, I'm reminded, is the last page of that tab. This document, he gave evidence, was a document which he had compiled in order to effectively to establish the number of hours sailing he had for the purpose, I think, of obtaining his appropriate sailing qualification. And one can see, therefore, that it's a slightly strange document because it covers a wide range of dates. Page 811, which is the handwritten entries on the log, we see that it starts in summer 1958. He refers there to having sailed on Coniston the weekends, so not in dispute that he knew Coniston, sailed on Coniston. And the material entry is 3 from the bottom, against the date on the left-hand side, 1975, July, bought 505, and then in handwriting beneath the entry 100 hours, which was the material entry so far as he was concerned, because it was in order to need to establish how many hours sailing he put in. We have the entry sold July 76, and the Crown submitted that he'd been caught out at trial because he said the boat was sold in June 1976, whereas his own log effectively established that the boat was sold in July 1976, and he said that this entry must be wrong. The point that was available to be made at trial, and no doubt was of course that this is not, it appears, a strictly chronological document. Quite why the date of the sale of the boat appears there is difficult to divine. But in any event, having provided it to the prosecution himself, to the police himself, it's extremely unlikely to have provided them with material which would then undermine his own evidence, if in fact the significance which the Crown sought to attach to that, it was properly made. There is this other point, of course, which is that if Mr. and Mrs. Young were correct, and it was an important part of the Crown's case that they were, the body was dropped in the lake in the middle of the day, it has to be said, in view of the shore, on the 29th of July, or thereabouts. They thought they'd been on, their holiday started on a Saturday, and they thought it was towards the end of their holiday. So it's thought that it was about the 29th of July when their observation took place. That would only leave him some 3 days in order to sell the boat by the end of July, if this entry is correct. So it's our submission that the point that was taken about the date of sale was not a good point. And then one had this difficulty with the Young's evidence, which everybody accepted, which is that they independently had identified a location on the edge of the lake which was about a mile away from where they said, or a mile away from where the body was recovered. They accepted that they could not have seen what they say they saw had they been where they said they were. If it had only been one of them who had identified that location, that would be one thing. But both of them independently identified that location. So the point could be made, and was, I know, forcibly made at trial, that they could not have witnessed Mr. Park disposing of the body. So that element of the circumstantial case, in our submission, was perhaps not as strong as the Crown were suggesting. There were clearly submissions which could be made which went the other way. And we've identified a number of features in our perfected grounds of appeal. Now, I've started by addressing the court about the circumstantial case, because the net effect of it is this. There were perfectly proper submissions which could be made by either side in this case. There were clearly points which could be taken in support of the Crown's case, on the circumstantial case, by the Crown, but there were equally points which could be taken by the defence. One point which appears to have got rather lost in the overall scheme of the evidence was the statement of a woman called Mrs. Baines, whose statement was read and was summarised in the summing up, to the effect that she had seen the deceased at a service station on the M6, which was some 80 miles south of Lees and was south of Blackpool. She thought on the Saturday, the 17th, because that was the day she thought she was going on holiday. Well, that's the day she went on holiday with her husband, and she thought that it was that day, but then she had second thoughts and thought that if they went after her husband had finished work, it would have been on the Friday. And so the way it was left at trial, according to the way it was summed up, was that both counsel considered that she must have been referring to the Friday. Well, with the greatest respect, that would have made no sense at all. If she were correct in her identification, then it raises the question of what on earth Carroll Park was doing 80 miles away from home, going south on the Friday. Where did she go from there? The very great likelihood in our submission is that Mrs. Bain's first impression, which is that it was the Saturday, was correct, and that, of course, would mean that she had gone off with somebody else.
We're not really in a position to deal with this in this level of detail because this was an issue that was raised at trial.
Yeah.
And the evidence was read
Yes.
by agreement,
Absolutely.
and the judge summed it up, as indeed the rest of his summing up, with impeccable fairness.
Oh, indeed.
So we can't really start to unpick these
No.
sort of points.
No, we can't. All of these submissions are directed to this point, and I'm afraid I'm repeating myself. There were a number of points which could be taken by both sides,
And no doubt were taken by
and were taken by both sides. Ultimately, one doesn't know at this distance in time, and the court can never know what it was that drove the jury to the conclusion that the prosecution case was correct and the defence case wasn't. But this was not, in our very respectful submission, as strong a circumstantial case as it has in the past been suggested to have been. There were a number of issues here which we submit didn't really make sense if it was the appellant who had carried out the crime. For example, just another example, the prosecution relied very heavily on the fact that on the Sunday, the appellant had been visited by an old friend of his who had moved away from the area and come to see him with his wife, and he had told them, the Shorts, that Carol had gone missing or had left home the previous day, and she'd left her handbag and her purse. And the Crown understandably submitted, well, if she'd left her handbag and her handbag and her purse were really there, then she cannot be true that she would have left home without those items. That point was made. It was made very forcefully. But the counterpoint to that is this: that the appellant would not have told anybody that she'd left these items behind, if in fact it wasn't correct, and if in fact he had disposed of her body and was going to have to explain it away by saying that she had left home. It would obviously be inconsistent with that story, that she'd left her handbag and her purse behind. So why on earth then did he tell the Shorts about it? Again, it's just another example, if you like, of the arguments which were available on either side in this difficult case, because it is no submission, a far from straightforward case. Can I then, against that background, please, turn specifically to the grounds of appeal? And the court has these in our perfected grounds, starting at page 8. First ground of appeal concerns the failure to disclose the evidence that which was known to the prosecution, that at the time he made his second statement, Mr. Wainwright was withdrawing from heroin. Just to remind the court of Mr. Wainwright's second statement, and for the court's reference, these are in volume 2 at tab. Just one moment. Tab 11. The statements. In his second statement, he had told the officer that he remembered that he had been told by the appellant that he had disposed of the axe which he had used, or had buried the axe on the shore of Coniston. What he said exactly, this is page 644 of the bundle. I remembered Gordon Park had told me during the conversation that I had with him about the axe. He said he had buried it on the shore of Coniston between the boathouse and the water. Can't be any more specific. What we now know, of course, is that, as one would expect, a search was conducted. We don't, in fact, have any information as to precisely where they looked or the details of the search. By the time of trial, defence counsel knew that there was a search had been conducted and made the point in cross-examination of Mr. Wainwright that the defence had not been told that anything had been found, so the assumption was that nothing was actually found. But we don't know exactly how extensive that search was because we don't have any material about it. The CCRC, in their statement of reasons, have referred to the fact that there was such a search. And we, very late in the day, have been provided with the material which shows the parameters of the search and the instructions that were given. But there it is. That's the context. And it was in that context that he appears to have told an officer, the officer who spoke to him, D.S. Marshall, that he was coming off heroin. The question, and that information was not disclosed. That information, it appears, was known to the prosecution, but was not disclosed. The question really, and this is what this ground of appeal comes down to, is what impact that non-disclosure would or might have made to Mr. Wainwright's credibility and the approach of the court to his credibility. Now, the court does have the benefit of the transcript of Mr. Wainwright's evidence, and it is perfectly clear that there were a number of points which could be taken which undermined his credibility, his shifting versions of events, for example, his background, his unstable state, and so on and so forth. And he was cross-examined extensively and vigorously, as one would expect, by defence counsel at the time. But what the defence were not able to establish, by way of a knockout blow, if you like, was that he was lying in the witness box. An important point, of course, which the Crown relied upon at trial, was that his evidence had been corroborated by his reference to the ice axe and the fact that Mr. Park, the appellant, had possession of an ice axe. And we have in the grounds of appeal set out, so I don't need to take the court to the relevant passages in the bundle, at pages 11 and 12 of the affected grounds, the appropriate passages from Mr. Wainwright's evidence. He said that his memory had, rather curiously, got worse as a result of stopping taking hard drugs, as he put it. It appears that the reason for that evidence was in order to explain his shifting evidence. In other words, that he remembered in 1974 that the axe, that he'd been told that the axe had been buried, and then his different version of events on the day before he gave evidence, and on the 30th of November, when he said that he gave a further version of events in which he said that the appellant had told him that he'd come home He'd found his wife in bed with another man, he'd chased him, and then he'd used the axe to attack him. So in trying to explain away his shifting versions of events, he fell back on saying, well, you know, my memory's got worse as a result of being off hard drugs. And so in the passages which we've highlighted at page 12, we see this. It was put to him, this is the top of page 12 in the affected grounds, your mental processes, have they been getting worse and worse and worse throughout that period? And he said from 1997 they've gotten worse because I'm no longer using any of the other hard drugs. I'm only using cannabis now. And then he goes on, the question is put, so as far as you've given up all those really dangerous drugs, you found that that has had the effect of making your brain function worse rather than better. No doubt a question asked with eyebrows raised, and he says yes. And then a further passage, a passage which we've underlined in the grounds. You told the jury that your memory had declined since you stopped using the more serious drugs in 1997, yes. Why did you stop using those drugs? Because I wanted to come off them. So he told the court that he wasn't using hard drugs. That's the point. It's a simple point. It was a lie. He had been taking heroin, certainly when he made the statement in the middle of 2004, and plainly, and Sir Andrew Regis, when he was asked about this by the Criminal Cases Review Commission, made the point that clearly if he'd had that information about the heroin withdrawing, then he would have put it to him. But he would have put it to him with some effect in our respectful submission, because he could have pointed out not only was this man unreliable, but he was lying to the jury. And that's really the sting, if you like, of this evidence. And that is why this non-disclosure in our respectful submission has a real impact. We cannot know exactly what the jury made of Michael Wainwright. It may be that the jury approached his evidence with a degree of scepticism.
Well, they were certainly directed to do that.
Well, they were given the appropriate directions.
Very firm directions.
They were given appropriate directions. But the fact remains that he was an important witness at trial. He was one of the witnesses who caused the prosecution to be brought. And not only that, Mr. Webster dealt with it in this way. He said, you can say what you like about Wainwright, you may have doubts about Wainwright, but just remember the axe. The ice axe was found, and it would be a very strange coincidence if he didn't say that, if he didn't mention the ice axe. So a lot of reliance was placed upon that aspect of his evidence. And so it's my submission that it is at the very least perfectly possible that this single feature, in other words, the fact that he'd been lying, would have made a difference to the jury's approach. Nobody can ultimately know, but there is a very real possibility that it would. And then, can I then just deal with the question of the fact that he was arrested in 2005, shortly before the end of the case, and charged with possession of cannabis and amphetamine with intent to supply, or maybe even substantive supply.
What was the date of his charge?
It was, there isn't in fact, it's referred to in the statement of reasons. It's referred to as being in January 2005, and he pleaded guilty on the 22nd of February at Preston Crown Court. He was arrested on the 19th of January. We don't know the date of the charge. He was arrested on the 19th of January.
Towards the end of the trial?
Yeah, towards the end of the trial.
When did the trial, what was the start date of the trial?
The start date of the trial was the 28th of November. I'm very grateful. 25th.
October or November?
No, November. And he gave evidence on the 30th of November.
which is in fact the date of his last statement. He provided a final statement just before giving evidence.
So trial starts on the 25th. He gives evidence on the 30th of November. He's arrested on the 19th of January.
That's right.
And pleads guilty on the 22nd of February.
The evidence was continuing on the 19th of January, the last defence witness. It was the day before the last defence witness was called. Mr. Webster accepts that had he known about this, it would have been disclosed to the defence. That was his attitude when interviewed by the Criminal Cases Review Commission.
But that's not accepted for...
No, it's not. No. The Crown submit that this would not in fact have been disclosable. We submit that it plainly would have been disclosable and would have been admissible at trial had it been known about. For this reason, of course, Mr. Wainwright had painted himself as somebody who was just a heavy cannabis user, whereas in fact, with the benefit of knowledge that he had been arrested for supply of amphetamine and cannabis, that can't have been true. It was very unlikely to have been true. But secondly, and this is also important in our submission, it would have provided the basis for a submission that he had a motive for giving evidence for the prosecution. Mr. Webster noted when he originally advised about the strength of the case, about Mr. Wainwright, back in December 2003, that Mr. Wainwright had been an informant, although he wasn't an informant at the time. But that would mean that he would be well aware of the benefit that might attach to him by cooperation with the police. And of course, if he'd given evidence to the prosecution, then that would stand him in very good stead if he himself were further arrested. Now, what we don't know...
I could see that there might be something for that argument if the chronology had been different. But what you're saying is that he went to... when was the first day that he contacted the CPS?
It was immediately after the programme, so it was the 13th of September, 13th, 14th of September.
2000 and...
2000. No, 19... Yes, 2000.
In 2000?
Yes.
And this was the indictment period in relation to the drugs charge was when? It spanned a year, I think.
I'm terribly sorry. January 04. Between January 04 and January 05.
So what you're saying is in 2000, he has in mind that it may be useful for him if in some future point, or what is the point exactly?
Yes, he was living in that world. He was within that world in which, if he's going to be continually involved in criminal activity, and he knows he is, and we know from his arrest in 2005 that he was, then it's always going to stand him in good stead if he can say, well, I've helped the prosecution here. I've given evidence in a very important case. What we don't know is whether or not a text was provided for him in February 2005 when he appeared in court. But that's the significance of that further arrest in my submission. It firstly undermines his evidence, but also a trial. Of course, if he'd been in the witness box and defence counsel had this information, they could have put it to him. Well, Mr. Wainwright, you're actively involved, aren't you, in the supply of cannabis and amphetamines? Yes. Going to court? Yes. Is it intended that the judge's attention is going to be drawn to the fact that you have given evidence for the prosecution? Yes, you may have said. Which, of course, would have provided him with the motive which the prosecution said didn't exist. I mean, they say he had a conscience, and of course the defence case at trial was that he was an attention seeker. I mean, that's really as far as it went. That was said to be what underpinned Wainwright's evidence. That's our ground of appeal number one. It's the non-disclosure of the fact that he was withdrawing from heroin, still using hard drugs in 2004, and the fact that he was actively involved as an active supplier of drugs, something which Mr. Reed has said to the CCRC he would have deployed in cross-examination had he known about it. Can I then please turn to the ground of appeal concerning the non-disclosure of Dr. Tapp's opinion
Yes.
in relation to whether or not the ice axe was likely to have been the implement that was used in order to cause the injuries to the deceased's face. The significance of this ground of appeal in our submission arises from the reliance which was placed on the finding of the ice axe by the prosecution. The prosecution at trial knew that Dr. Tapp's opinion, which to summarise it, and the court has this information, was that the ice axe was unlikely to have been the implement to have been used. They knew about that opinion, and it must have been, we would ask the court to infer as a result of that, that he was not shown the ice axe at trial. Because had he been, to the knowledge of the prosecution, he would have said, I think it's unlikely that this is what caused the injuries, was used to cause the injuries. But that did not prevent the prosecution from specifically linking the finding of the ice axe to Wainwright's evidence. It's now said that the reason for doing that was simply to provide some corroboration for Mr. Wainwright's evidence. But the court should remember that this detail wasn't some peripheral detail relevant to his credibility. Mr. Wainwright had said that the ice axe was the murder weapon, essentially.
Well, there's an ice axe with a black handle and a metal shaft.
Yes, but an ice axe nonetheless. An ice axe, and it was a strange coincidence of the prosecution that an ice axe was found in Mr. Wainwright's possession, in Mr. Park's possession. I mean, it couldn't sensibly have been suggested, in fact, that the ice axe which was recovered was the implement, because it would be extremely unlikely for him to have retained it if it was, the court may think. And one then, of course, has Mr. Wainwright saying that, in fact, the axe had been, he'd been told the axe had been buried. But the point is, he was a climber, he had an ice axe, he used to have an ice axe, so there would have been another one. So that was what the significance was. I mean, that's the point of linking the ice axe to Mr. Wainwright's credibility. The prosecution.
And the important word there is ice, isn't it? But
Yes.
in this context, because chronology shows that Wainwright had seen the television, or he said he had seen the television programme where Dr. Tapp had mentioned an axe,
that's right.
as a possible implement.
Yeah, no, that's right. The television programme didn't say that it was an ice axe. When he was interviewed by the police, the appellate had said that he had mentioned to people when he was in custody that he was a climber. He used to climb. The question which does arise, if this is my lady's question, is you know, how would Mr. Wainwright have known that he had a climber's axe in his possession, were it not for the fact that he was told something to that effect? But that in our submission doesn't go to the fundamental point. The fundamental point is that Mr. Wainwright had said, and I'm repeating it, I know, that the axe had been used, the ice axe had been used, the climber's axe had been used, in order to commit the crime. So, without spelling it out, because the Crown couldn't specifically spell it out, because they knew what Dr. Tapp's opinion was, nonetheless, they left the impression they allowed the impression to be given that indeed the ice axe had been used, that was, or an ice axe had been used, that Mr. Park was somebody who possessed an ice axe, and that's why it was such an important piece of evidence. Of course, when they searched the Lake Coniston, the police weren't in fact looking for an ice axe. They were looking for a wood-cutting axe because they knew what Mr. Dr. Tapp had told them.
Kindling axe.
Kindling axe. It's of some importance that in their responses to the Commission, both prosecution and defence counsel independently have agreed about the importance of the ice axe to the Crown's case. The respondent submits that their memories may be a little unclear about that.
The best, I mean, this is the disadvantage of not having a full range of transcripts. The best material we have as to what actually was significant or not is you can point to what's in the prosecution opening, but the summing up, is it not? Is that not the place at which matters which are material must be flagged up for the jury's consideration?
Yes, that's obviously important, and we've pointed to the relevant passages in the summing up in the grounds.
There's been rather a long time. What happened? We're talking about events in 2004-5, and counsel who appear, and obviously what was a high-profile and notable case.
Yes.
Relying on their memories without access to case papers. That's really the question: is what significance we can attach to their recollection 14 years after the event, 13 years after the event.
Absolutely, but defence counsel at trial, the court will remember, asked a prosecution witness, Mr. Shaw, to look at the axe in order to effectively discount it or give an opinion as to whether or not it was likely.
That he could not believe that Mr. Park would have used anything like that. Precisely.
Which of course means that the defence were approaching the case on the basis that the Crown's case was, without specifically putting it to Dr. Tapp, that was, the ice axe may have been used. Why else would Mr. Shaw have been asked about that? And the way it's dealt with in the summing up, we've set out, I don't want to take the court to the relevant passages in the summing up itself, but our paragraph 2.25, which is page 21 in the perfected grounds. My lady, can I just just mention this? One of the representatives from the Commission is in court, who's done a lot of work on this case, and he tells me that barristers did have access to their case papers when they were interviewed by the Commission. I simply mentioned that. But yes, the relevant passages are this. In the summing up, Mr. Shaw, he refers to Mr. Shaw's evidence, that his friend of 50 years standing said he couldn't countenance the idea that Mr. Park had used that ice axe in the dreadful manner that might be suggested in this case. So the fact that that suggestion was being made and then summarising prosecution counsel's closing speech, and we have this at paragraph 2.26. There were elements of Wainwright's evidence which you may have thought to be supported by common sense and the evidence. There is no suggestion that the use of an ice axe was mentioned in any TV programme. This was an invention. It was an extraordinary coincidence that it just happens that Dee was a climber and had to our certain knowledge of climbing axe. Bear in mind, of course, obviously described a black axe, whereas when the one recovered from the D was wooden, an ice axe nevertheless. My principal point is this: one can't divorce what Wainwright's mention of an axe from what Wainwright says the axe was used for. The Crown were relying on Wainwright's evidence, not just to the effect that he knew that Mr. Park was a climber who had an ice axe, but this was the very axe which had been used to cause the injury. That was really the point of it.
He wasn't saying that.
I'm terribly sorry.
He wasn't saying that. He was saying that the axe that was used was one with a black handle and a metal shaft. And this was a wooden through and through ice axe, apart from the blade and the point.
Yes, but it's the coincidence is this. This is a man who, I've in a way already addressed this point, but it is a person who, whether it was this axe or not, was a climber who had possessed an ice axe over a period of time. Whether he replaced it with another one or not, perhaps it's not material ultimately. But the point about Wainwright's evidence is that he was saying that it was that ice axe that was used. Now, taking aside the question of whether it was Exhibit 1 that was used or whether it was something similar type of implement, the sort of thing that a climber would have, it was absolutely at the heart of Wainwright's evidence that that implement was used to cause the injury. And in my submission, in our submission, that is precisely why the prosecution attached the importance that they did to it. They couldn't spell out precisely, they couldn't pin their colours to the mast saying, well, it was the ice axe that caused the injury, because they knew what Dr. Tapp's opinion was. But knowing that, they should have corrected any misunderstanding that there may have been by disclosing what Dr. Tapp's opinion was. And not to do so in our submission was fundamentally unfair. And we know, of course, that in the aftermath of the case, a letter was sent by the appellant's solicitor asking about whether Dr. Tapp was shown the ice axe. And the reply was given that he was shown the axe, but said he couldn't say whether that was the implement or not. Well, that was the opportunity to disclose to the defence at that stage that he'd gone further than that and said that, in fact, it was unlikely to have been the implement that was used. So the inference, I'm afraid that we have to ask the court to make, is that there was deliberate concealment of that from the defence. It's difficult to understand why this wasn't disclosed to the defence. And the Crown accept that it should have been there. The respondent accepts that it should have been there. It can't be a satisfactory explanation that the Crown's case was always that, was never that, it was the ice axe that was used. That's not a satisfactory explanation. They should have put this issue to bed by saying, well, the pathologist says he doesn't think it was. And we know how the pathologist, Dr. Tapp's evidence has.
We don't have a statement from Dr. Tapp saying that, do we? We don't have a statement from Dr. Tapp, contemporaneous or afterwards, saying that.
That it was unlikely.
Yes.
We
have is that note.
Yeah, we have the reference.
An internal CPS note recording
Yes.
what he said.
Yes.
And then there was a conference with counsel at which he didn't say that, or rather the recorded note of conference with counsel does not record that he said that. Yeah. I mean, your point is they should have taken a further statement from him, and it's accepted that they should have taken a further statement from him. But you can't go as far as to say that there was a statement from him in which he said that.
No, there wasn't a formal statement, no. I accept that. But that is really our point.
But given the difference between, my point is, given the difference between what was recorded in the internal CPS note and what subsequently was recorded in the conference with counsel, there must be some debate unresolved, because we don't have a contemporaneous statement, about what precisely Dr. Tapp would have said if he was asked to produce a statement at the time.
Well, I think we know from the internal notes that he consistently said that he thought it was unlikely, having seen the ice axe, that it was the ice axe that was used.
But he couldn't rule it out.
No, he couldn't rule it out, but he thought it was unlikely.
That's what the conference note said.
Yeah, he couldn't rule it out, but he thought it was unlikely. And he explained why he thought it was unlikely. And then he's gone on to explain later that he thought, in fact, it would have been the blunt end of if it was an axe as opposed to an ice axe, it would have been the blunt end as opposed to the bladed end of an axe. But it would have been so easy to disclose this material, and that issue could have just been put to bed, and the prosecution's submission in relation to the credibility to be attached to Wainwright's evidence would undoubtedly, in our respective submission, have been undermined by disclosure of that material. It goes a bit further than that, of course, because it was principally directed to Wainwright's credibility, because that's where it came from, the question of the axe. But of course, in the absence of evidence to suggest specifically that it's unlikely to have been the axe, the suspicion would have been left that that might well have been the implement that was used to cause the terrible injuries, given that there was a sharp-edged implement which was used. I haven't taken the court to the respective notes which are in the files. We've referenced them in the grounds. The court has them. Unless the court would wish me to do so, it seems to me that it's not going to assist the court greatly, unless the court would wish to consider various entries.
No, speaking for myself, the answer to that is no, we don't need to do that, because you've very helpfully summarised and identified the different statements and the submissions that are made in relation to them.
Can I then...
Mr. Bax, I'm sorry, before you go on, while we're dealing with notes in relation to pathologists, Dr. Lawler was shown Mr. Graham's attendance notes.
Yeah, no, I don't have them. I wondered about that, funnily enough, as well. I was finishing off the perfected grounds. There is the various documents, actually, which are referred to in the reference, which had not originally been produced. For example, the sequence of correspondence post-trial, which we now have inserted. No, that shows us, on the face of it, that there was a discussion between Dr. Lawler and Defence Counsel.
Yes,
about that.
And the CCRC report tends to indicate that they had had access to those notes, but they haven't made their way to you.
They've not made their way to me. I can make the further inquiry. I made the further inquiry about one of them. I ought to have followed that up, actually. I agree. But we can certainly do that. Can I turn then to the question of the expert evidence, the new evidence from the dentists, the odontologists?
Yes.
The first question is this: whether or not leave is required in order to argue this ground. This is a point with which two members of the court will be familiar, because it arose in a recent case, but it's paragraph 14.4a of the Criminal Appeal Act. Can I just hand up the Criminal Appeal Act? Just so you have it. Sorry, Richard, I'm not going to spare. Yes, page 2 of the document I've just handed up, 14.4a, subject to subsection 4b. Where a reference under sections 9, 10 or 12a is treated as an appeal against any conviction, verdict, finding or sentence, the appeal may not be on any ground which is not related to any reason given by the Commission for making the reference. So the question is whether or not this ground is related to any reason given by the Commission for making the reference. In our submission, it is related. It arises as a direct result of a report having been obtained by the respondent perfectly properly and in order to assist the court from their own pathologist, Dr. Fiegenau. It's in response to that, and that report from Dr. Fiegenau was obtained because it relates directly to the ground of appeal concerning the significance which should be attached to the non-disclosure of Dr. Tapp's opinion. So in our respectful submission, it does relate to a reason given by the Commission. Even if the court does not agree with us about that, it's our submission that it's in the interests of justice for leave to be granted. In the circumstances of this case, the court has, as I repeat a point I made earlier, already approved the instruction of odontologists to assist the court, and in those circumstances, it would be proper and in the interest of justice for the evidence to be received by this court of this ground of appeal to be argued. There is a question as to, which does arise from this, as to why this issue was not pursued at the time of trial. And indeed, the question of the opinion of whether or not the ISACs would have been a relevant candidate was not pursued. And in the respondent's notice, attention is drawn to the fact that the ISACs was requested by the defence to be shown to an expert who'd been instructed by the defence called Martin Everson from the University of Sheffield. And
Paragraph 67 of the respondent's notice.
Yes, that's right. And my Lord Mr. Justice Sweeney may recall that at the directions hearing, I specifically informed the court that I had seen correspondence and there was relevant correspondence in relation to it. And can I please hand up? I've shown this to my learned friend. The relevant pages. And I've numbered them so that they can be inserted in the relevant place.
Thank you very much.
And one can see from that, so behind tab 35 they should go, I think, which is the letter requesting production of the acts.
It says not sent.
Not sent, and that's the point. Why not? I simply cannot help the court with why it wasn't pursued, but I mean, it's an obvious inquiry. It shows that this issue was very much in the mind of the defence.
Do you know, I mean, it's not a very satisfactory way to get evidence in relation to this matter. We don't know anything about this apart from what you're telling us.
No, but I thought it appropriate. No, I thought it appropriate, given the issue that's been raised, that I've seen the correspondence and this is on the file. And if a question is raised about, well, what happened? Was the ISAC shown to anybody? If so, was there a report prepared? All I can tell the court is that it was in the mind of the defence to show it to Mr. Everson, but the letter, according to the correspondence file, is not sent. And there is, I can tell the court, there is on the face of the papers that we've been provided with, there is no opinion from Martin Everson concerning the likelihood of the acts having been the implement that was used.
What about his letter of the 17th of November?
Yes, I can provide that if you want, but it's on a different issue. I can certainly. If the court would wish to see the entire correspondence file, I'm absolutely content the court should do so. The court should do so.
Mr. Blaxland, we don't think this is a very satisfactory way of dealing with this matter. If you wish to put material before us, then it has to be done by way of evidence, if necessary with a witness statement or affidavit from your instructing solicitors, identifying exactly what is and is not on the file in relation to this, and you have to take a view about whether you waive privilege in relation to any communications with that there are or may have been with Mr. Everson. We can't have the odd document being handed to us with a handwritten note on it, and obviously you are told what you are told on instructions, but we have to proceed in a different way.
No, I understand.
What we will do is we'll put this point to one side for the time being. If you wish to make any point in relation to what is in and has been for a while now in paragraph 67 of the respondent's notice, then you must follow the appropriate way of dealing with that, as I say, by way of evidence rather than in this in this manner.
Very well. We'll do that. I simply thought that the court would be helped by...
But we're grateful to you for assisting in relation to the point, but it still has to be done in a way that that is satisfactory for the purpose of us drawing any inference or not, as the case may be, from what we have before us.
I think that this was by way of a preface to, if you like, a concession which I would make, which is that there is no satisfactory explanation as to why this particular issue was not pursued at the time of trial. The defence refrained from asking Dr. Tapp about the ice axe, no doubt warned off more or less by Dr. Lawler. But why the experts weren't particularly shown. We simply can't. You know, it's not satisfactory. I mean, I have to accept that. The question of whether or not an expert odontologist should be instructed is a different matter.
Yes.
Neither side appears to have instructed an expert odontologist. There was a dentist who was instructed, but he was instructed simply for the purpose of identifying the deceased remains. That's in fact how she was identified, but there was no expert odontology report. The question, therefore, is whether or not it's in the interests of justice in our submission that this evidence should be admitted, received by the court and admitted. In our submission, it is in the interests of justice. The evidence in our submission has this significance. It means that Dr. Tapp's opinion at trial, which everybody accepted, that a sharp-edged implement was used, is undermined by the fresh evidence. For this reason, as we can see from the statements, and I'll take the court to them, Dr. Tapp's opinion about the sharp-edged implement was based upon a combination of of his examination of the left zygoma cheekbone and the teeth. Can I just take the court to tab 13 in volume 3?
Yes.
Relevant passages. Page 706. This is his report from the inquest, the purpose of the inquest. He says at the top of the page, the facial bones were fractured into several fragments, and some fragments contained one or more teeth. And then 3 sentences further down the page, the 2 largest fragments from the facial bones were parts of the zygomatic bone from each side. All the fragments were later reconstructed, but when this was done, some parts appeared to be missing. Construction also demonstrated damage to the roots of the upper teeth on each side. Moreover, it appears that the anterior border of the zygoma on the left side has a sharp edge, suggesting it's been cut rather than fractured at this site. And then in handwritten entry, which presumably arose from his evidence before the coroner. When a bone breaks...
These are the coroner's notes, aren't they, on the document?
Sorry.
These are the coroner's notes on the
Coroner's
document.
notes, yeah, the coroner's notes. When a bone breaks, it might have received by being by something with a sharp edge. He's made that note. And then...
Well, I think it reads, when a bone breaks, it has a rough edge. This was straight, half inch. It might have...
Yes, I think that, lady, that's right, yeah.
Occurred by being cut by something with a sharp edge.
Yeah, that's right. He then, page 708, paragraph 4, said extensive shattering of the upper jaw was present. Towards the bottom of the page, the injuries are the result of several deliberate impacts in the central part of the face. They could be in the form of blows with a heavy blunt object or by kicks. But the appearance of the teeth and the anterior border of the zygoma suggests strongly that the implement also had a sharp edge on it and that the central part of the face was destroyed by at least 2 blows in the downward direction. The structure of the nasal and other facial bones, together with bleeding from such injuries, often results in upper respiratory obstruction and so on. And then he says to the coroner, the teeth had the appearance of shaving off in a downwards motion. Some tissue was shaved off. This also indicates the weapon had an edge, at least 2 blows. Cannot conceive of the injuries being accidental. An axe or chopper could have done this. I don't think a piece of wood, said at the inquest. Dr. Lawler's statement to the inquest, page 718, bottom right, under the heading Internal Appearances. He says in the middle of that paragraph dealing with the skull, consequently, the base of both occipital regions was extremely thin, and many of the normally thin facial bones associated with various sinuses, for example, the ethmoid, the lacrimal, the nasal, the palatine, the zygoma, and the upper part of the maxilla had disappeared, he said. But he agrees, bottom of the page, the planes in which the maxillary fragmentation had occurred did not relate to any anatomical distribution, and I therefore could not avoid drawing the conclusion that this must have been as a consequence of fracturing by blunt force trauma. And he further comments at page 720, bottom of the page, the only definite and significant injuries identified in this case relate to the fracturing of the lower maxilla. I find it impossible to imagine how this bone could have become fragmented in the way that it has, other than following direct blunt force trauma. And then Dr. Tapp's statement for the trial really follows his statement for the inquest. We just draw the court's attention to page 732 in the bundle.
What about on 715? That is not significant. This is the notes of Dr. Lawler's oral evidence. Maybe this has nothing to do with it, but he does deal with the question of teeth. Well, first of all, he identifies what he agrees and doesn't agree with. And then, in other words, he says, I agree with Dr. Tapp except for. And then on 715, I did see the teeth. I did see the striations on the teeth. I accept what Dr. Tapp says about that.
He also goes on to say the zygoma was injured, a sharp-edged cut, but he hadn't actually seen the zygoma. I mean, this is a point that Dr. Kohler makes, that in fact nobody apart from Dr. Tapp is in fact
Well, that's what they say now. The inference from the evidence as recorded is that the zygoma was seen.
Yes. Yes, the difficulty is this in our submission, that it's difficult to tell the extent to which Dr. Tapp's opinion that a sharp-edged implement was used was based upon or would have been based, or could have been based solely on what he saw in the zygoma, or whether or not what he was effectively saying is this is a combination of the injuries to the teeth and the injuries to the zygoma. What we do now know is that Dr. Tapp, as indeed were Dr. Figan-Earle and Dr. Kohler, were wrong to conclude that there were injuries to the teeth.
Put the teeth to one side for a moment. And the question, the notes that we've seen, a handwritten note of his evidence, deals discreetly with the edge of the bone.
Yeah.
It says it's not rough.
Yeah.
It's not a rough break. It's and so he does deal discreetly with it there.
He does. No, my lady's absolutely right. But with the benefit of the expert evidence, I mean, understandably, Dr. Tapp has not been further asked about this. It's many years after the event. But it is our submission that with the benefit of the evidence of the odontologist's reports, the question arises whether or not a conclusion that a sharp-edged instrument was used, given that that opinion was based upon observation of both the teeth and the zygoma, is now called into doubt. Because the way that Dr. Tapp put it, at page 732, which is his comment section of his statement, which is really more or less reproduces what he said in his statement to the coroner. His paragraph 4. the injuries are the result of several deliberate impacts on the central part of the face. These could be in the form of blows with a heavy blunt object or by kicks, but the appearance of the teeth and the anterior border of the zygoma suggests strongly that the implement also had a sharp edge on it, and that the central part of the face was destroyed by at least 2 blows in a downwards direction. Well, that opinion in our respectful submission may need, or does now need to be qualified, given the opinion from the dentists, and given that we now know that the pathologist simply was wrong about the teeth. So the question arises, was he right about the injury to the zygoma? It raises a question mark about that in my submission, which is relevant. And had that fresh evidence been available at trial, had this evidence been available at trial, it would, at the very least, have called into question in my submission whether or not there was sufficiently cogent evidence that an implement such as an axe with its sharp edge was indeed used. That's the relevance in our submission of the new expert evidence. Can I then turn to the final ground, please, which is the effectively revisiting, so we invite the court to revisit the geology evidence.
Yes.
Can I ask the court to return, please, to the decision of the Court of Appeal? Which is at tab 7 of volume 2. Paragraph 24, which is page 375 in the bundle. These are the reasons why the Court of Appeal questioned the importance of the geology evidence at trial. They say this: the evidence at trial as to how this rock came to be found so as to link it to the body was far from clear. No witness could say with any confidence how it came to be found. Can I just pause there? The point about the geology evidence was this, that it, although questions were raised about how the rock came to be found, the evidential weight of this evidence was based entirely on the fact that it had certain features in common with, which were said to be unique at the time of trial, in the experience of the experts, with rocks which were found at the defendant's home address of lease. And that, of course, is the way that it was put by counsel when the case was in counsel's closing address. Can I just ask the court to go to that?
Yes.
Which is in volume 1, tab 4. Is it? Mine's in volume. Maybe it's. I have mine in volume 1. Maybe it's been arranged in a different way for.
Yes, it's in volume 2.
Opening and closing. No, it's the opening and closing is tab 4. You want us to look at the closing, the opening and the closing?
Closing,
is in
yes,
tab
the
4.
closing, really.
So
It's the
closing.
closing,
What page?
It's page 328. That's the reference to the stone from the wall which was used to weigh down the clothes, and then at page 336 onwards, we have the...
Sorry, there's nothing about the stone on page...
Yes, sorry, it's at page, just simply by way of introduction, if you like, page 328.
Okay.
The submission is made.
Sorry, 328 in tab 4.
Yes, the stone is referred to higher up.
It is in mine, yes. It's page 13 of the original document. Although the idea that Intruder may have been the killer is floated in front of you, you can safely discard it. It's that passage.
Yep.
It's the reference to the stone being used to weigh down the clothes. That's really by way of introduction. But the significance is at starts at page 336. Significance of the clothes found in the lake. Where does this evidence take us? He dismisses makes the point which we agree with, that they must have been dumped by, that the clothes must have been Carol Park's clothes. And then at page 339, the middle paragraph, it's clear that the police didn't realise the significance of the rock in 1997. Examination was in 2004. And the next paragraph, counsel poses the question, was it merely a random stone that the scenes of crime officer chose or picked up with brilliant foresight to include in the exhibits on the off chance that it might match the wall from...
How big was the stone?
Do you know, I've not seen a picture of it. There was some mystery about it because it wasn't recorded when it was first...
I think it was because the bits were put together in the witness box, so we do know that they had the... You've seen its size. If it was not picked up as the clothing, how did it end up in the bag? I just wondered how big it was.
But I think the point that is being made is this, that although there were questions as to whether or not, or how the rock was found and where exactly it was, because it wasn't recorded, all of that paled into insignificance because of the geological features of the stone.
Yes, quite.
I mean, that's the obvious point. So in fact, I mean, the prosecution were able to argue very persuasively that this cannot simply have been a coincidence that this rock was found. I mean, that's the point. And to say that the Court of Appeal thought that it might make it significant simply because there was doubts about how it had been found. But with the greatest respect, that perhaps ignores the point the prosecution was making about the coincidence.
Yes.
And then page 340, three-quarters of the way down that page, counsel said, this is a very significant finding, is it not? We have the clothing dumped near the body, which logic tells you must be associated with the body. We have a rock, which is not from Coniston, but is both rare and matches the samples from bluestones several miles away. The rock was not in a position where it would have been casually dropped by a picnicker. It was not a skinner. You can exclude it spalling off and floating uphill or having been deposited by a glacier 10,000 years ago, and then having worked its way up through the silt. And so the Crown attached considerable significance to this part of the case at the time. At page 28, page 343 in the bundle, we have a passage which has been struck through on the document with which we've been provided, which summarises the submissions which the Crown were making. And I'm picking it up at B. In all of the selected stones from bluestones, this same rare combination was found. It was not found in any of the comparator rocks. It would thus appear to be a huge coincidence that the stone recovered with the clothes happened to have this rare combination, whereas the stones from Coniston did not. Now, although that's been struck through, we know from the summing up that the word coincidence was indeed used by Mr. Webster in his closing address, effectively to exclude coincidence. So it's our submission that very significant weight was placed upon this at the time of trial. Although with the benefit of hindsight, of course, it has become clear that the warning which Professor Pye had given to the court about the absence of sufficient samples should have been accorded greater weight than it may have been, because subsequently, of course, with the benefit of the statement from Dr. Moncrief, with which Dr. Pirrie agreed, we can see that from the Court of Appeal's judgment, becomes clear that no weight at all can now be attached. But this was the only piece of forensic evidence which appeared to link the defendant to this crime. There was no other forensic evidence as such. And on the face of it in our submission, it was a very powerful point for the prosecution to have been able to make. And the defence at trial were not able adequately to deal with it. They did the best they could by reference to generalities. But the simple point that none of the rocks which were recovered from the lakeside had this particular feature, and yet rocks which were recovered from the appellant's home address did, was a powerful point. And therefore, in our submission, the approach which the court should invite the court to make now is to reconsider this point, although it was dealt with by the Court of Appeal on the last occasion, in the context of the other grounds of appeal in this case. And the consequence of that in our submission is that the evidential weight to be attached to the various components in the Crown's case against the appellant has now shifted to such an extent that it cannot properly be said anymore that this is a safe conviction. To repeat, there were arguments on either side. Slowly but surely, elements of the Crown's court case have been chipped away. And that, in our submission, should cause the court to doubt the safety of this conviction. My lady, those are our submissions, unless there's anything else at this stage with which the court would...
Not at this stage. Thank you very much, Mr. Blaxland. Yes.
Lady, can I just, first of all, deal with what we think is a correction? Could I just show the email to Mr. Blaxland, first of all? Check if it was only in relation to Mr. Edis's answer, comments to the court from behind as to what papers were available to Mr. Webster and Mr. Edis. And certainly the case review manager at the CCRC sent an email to the lawyer at the Criminal Appeals Department. And the answer was, Mr. Webster and Mr. Edis and Dr. Tapp were all asked weeks prior to the interviews whether they would like to be provided with copies of any documents relating to the case, including the summing up, to refresh their memories. All declined, stating they had good recollections of their case. In terms of access to material prior to the interview, I cannot speak for Mr. Webster, but I can say that Mr. Edis had retained a lever arch file of papers relating to the case including conference notes, and Dr. Tapp had consulted his retained case file, to which he referred during our meeting. During the interviews, I produced copies of any documents to which my questions referred, statements, transcripts, reports, conference notes, etc. And then deals with taking the witness.
That was sent to the Court of Appeal office, did you say?
It was sent to the Crown Prosecution Service, made the inquiry,
Yes.
and that's an email from the case review manager at the CCRC.
To whom? To the CPS?
To the CPS lawyer. And it was only given the answer that was given.
Could we be provided with a copy,
Certainly.
please? Thank you.
And Miss Oakley, who located that, will do that immediately.
Thank you very much.
Other matters, just as to dates, to put things into a chronology. The trial, on the full transcript, not the one that's in the court bundle, says that it started on Thursday the 25th of November and ended on Friday the 28th of January of 2005. And that certainly deals with the jury returning its verdict on that day. And that as far as of perhaps relevance as to when witnesses gave evidence, because it might help us to who was asked what when, it was on Tuesday the 30th of November of 2004 that Wainwright gave evidence. He was the only witness that day, and as Mr. Blaxland has said, he provided that further statement on that day. And on Wednesday, the 1st of December, so the very following day, the first witness who was called was Paul Shaw, so the man who was asked about the ISACs in cross-examination by Mr. Eagles. It was then the Shorts gave evidence, and then it was Dr. Tapp on the 1st of December. And so the court had received the evidence of Wainwright in relation to an ISACs, described as he described it. The very next witness was Paul Shaw when it was put to him in cross-examination. And it was Dr. Tapp's evidence received later that day. So, my lady, I hope that assists just with the chronology of what actually took place in the trial. In our respondent's notice, we dealt broadly with the circumstantial case that was available, starting at the bottom of page 5, paragraph 16. Lady, I won't read them all out, the court's got them, but if I may be permitted to make just some comments in relation to them. There'd clearly been difficulties in the relationship, and there'd been a separation, and she had mentioned she wanted a divorce. That separation ended in August 1975. She returned to the matrimonial home in August 1975 because the appellant had been awarded custody of the children. And it's clear that she did not want to live apart from the children. And obviously a influencing factor on her return was to be with the children. When she had left the matrimonial home previously, she kept in touch with the appellant, her family and friends, and had maintained access with the children. And she'd completed the summer term at the school where she taught on the 16th of July and was not due to return until the 2nd of September. Pausing just to add this comment, so she, on the face of it, appears to have been murdered at the end of that term, when she was going to be effectively at home with the children for the summer. And she wasn't to return work until the beginning of September. It was only just into September that, in fact, the appellant reported her missing formally. She'd given no indication to anybody of a plan or intention to leave the home. In fact, she seemed to have enjoyed her time at school. She'd expressed her enthusiasm to enjoy the summer holidays with her family, including the trip apparently to Blackpool. She was making plans in relation to the autumn term and her work, and she'd given her sister-in-law money towards the Christmas club for the future. And it was the appellant who'd said that she had suddenly left and decided not to go on the trip. It was his, as the court knows, position that there'd be no forced entry to the matrimonial home and no disturbance. He doesn't appear to have made any real inquiries as to her whereabouts after he had returned from Blackpool, whether it be hospitals, doctor, friends or family. And she has, as the court knows, left behind her wedding and engagement rings. Her bag was also there. She'd continued to wear those rings when she'd left previously. A comment's been made about the visit from the Shorts and the fact that the appellant volunteered the presence of those items. One could comment equally that he didn't know they weren't going to come into the premises, where no doubt the bag and rings would have been evident, and he may simply have been preempting a comment about that. The relevance of the purse and the handbag remaining is, of course, she wouldn't have had access to any financial means. There would have been no purpose her leaving it behind if she had left voluntarily. And Mr. Blaxland, as I understand it, concedes pragmatically that any departure from the family home, given the circumstances it remained in, must have been consensual. She left without any difficulty. So there's no real sense in the handbag being left there. The majority of her clothes remained. I've already observed the comment about the money. She was, of course, still wearing her nightdress when the body was recovered. We don't accept Mr. Blackland's argument that therefore she must have been murdered in the bedroom. There's no need to confine yourself to the bedroom wearing your nightdress if you're in your own home. And it is relevant that the sack that was made to put the body in was in fact made out of one of her own items of clothing in any event. Whilst arguments have been put forward about the type of boat that might have been used to dump the body, it's inescapable the fact that the appellant was extremely familiar with Coniston Water. He'd sailed there since he was a child, and he accepted in evidence that coincidentally the body was found directly opposite where his family had had a caravan and he had holidayed as a child himself. And he'd owned and had access to a white boat in July of 1976. Mr. Blaxland's addressed when or how it might have been sold. Looking at the document to which he referred, it's on the same line as to when it was bought, as to when it was sold. It would make sense to make that entry there. And there is, of course, the point about whether or not he was accurate when he told people of when he had sold that boat. There was some significance put on knots. I don't put that particularly highly, but he was somebody who had that skill. Others would have, who sailed and climbed in that area, but it is something that he was familiar with. The rock was relied on, and I can't go behind any of Mr. Blackton's submissions as to what the prosecution had said by way of closing. But it was, if the generality of the circumstantial matters that I am raising in generally, it was but one of over 20 circumstantial points. The Youngs did describe in July somebody depositing an item, a large item from a white boat in Coniston Water, but there is the issue which was plainly explored as to where that was. There was no credible sighting of her after the 16th of July. And although there's always that very grave caution as to if I can call the evidence of the two people from custody as cell confessions, not necessarily made in a cell, but this court and all courts have great caution about those, but they were part of the evidence and fully explored before the jury. And so it's our submission that there was a strong circumstantial case against this defendant, sorry, this appellant. And I don't go behind the fact that this is a CCRC reference and the court, of course, obliged to hear it. But the reference itself made plain that it was based on the cumulative effects of the four grounds that the Commission put before the court. And in our submission, it's not without significance in looking at that cumulative effect. But what might have been considered the most powerful ground, that of the DNA, on further examination has fallen away and quite properly been abandoned. We submit in the court's assessment of the safety of the conviction, it's important to look at the grounds that remain, and they were only referred to this court on a cumulative basis. Given the lady's observation to Mr. Blaxland about the well-trodden ground as far as the test of this court was concerned, I wasn't going to address the court in relation to how this court was going to, it should approach.
And both sides have very helpfully set out their stall on that in writing.
In which case I won't trouble the court with any oral submissions. Can I just, merely as a matter of detail to assist the court, there's reference made to Burridge, and it's only from my own researches, if Burridge is researched in the criminal appeal report, all that is available there, I'm sure out of no, not doing justice to Lord Justice Levison's judgment, there's the beginning and there's the sentence point. Actual substantive law is not reported.
Well, if you've got a report...
We'll hand them up later and we'll send them electronically. But to say looking for it, it reads rather interesting.
Thank you.
As far as the evidence of Wainwright was concerned, in our submission, he was subject to effective and forceful cross-examination by Mr. Justice Edis. The transcript of that cross-examination...
I think you better call him Mr. Edis for this purpose, because I give the misleading impression that the judge was doing the cross-examination.
Absolutely, and I apologise for that. but the transcript is some 40 pages long of the cross-examination. It is, if the court wants to look at it in volume 2 at divided 12, it starts at page 9 and goes on to page 49. It was summed up clearly with the appropriate warning from page 137 to 140. And our submission is that, but for the identified issue that he was still taking hard drugs, that was a skillful and effective cross-examination. And by way of illustration, I'm making absolutely no criticism of the cross-examination at the time. Cross-examination of a witness like that today would be very much shorter and in a very much tighter compass. Points will be there to be made, perhaps not made to somebody who had mental issues and a history of drug taking as extensively as they were. No criticism at all, but that helps put into context the inroads that were made into his evidence. And so we set out in our discussion points matters that I won't repeat, but at page 14, paragraph 46 of our respondent's notice, including at 46.9, it was someone that the doctors did not believe. He blamed paranormal forces for his actions and that his home was possessed by a poltergeist. He had a history of hearing voices and the like. And he, the differing accounts that he'd given, including that statement on the very day that he gave evidence, were all explored in detail. And the summary in the statement of reasons is perhaps referred to our paragraph 48, page 15. The centre of that paragraph, factual discrepancies between his statements and the live evidence he gave before the jury was fully explored. Paragraph 76 of the Statement of Reasons, the appellant accepts that Mr. Edis conducted a robust cross-examination of Wainwright by reference to his drug abuse, his failure to come forward before the television programme, which has included most of the details he had recounted, and all the changes, inconsistencies, and inherent difficulties in his various accounts. And as the lady's already observed, at the very bottom of that paragraph, the trial judge gave the warning that the evidence should have been dealt with extreme caution. He didn't stand alone as a witness to whom the appellant apparently confessed to his part in this murder. They're all matters that were before the jury, and we submit that the further matters in relation to his continued drug taking, whilst of course should have been disclosed, do not have a significant impact when his evidence is assessed as a whole in the context of the trial.
Mr. Whittam, I seem to remember having read somewhere that maybe it was the defence in closing, maybe it was summed up by the judge, I was just trying to find it, that the cross-examination of Mr. Wainwright had been sufficiently effective for someone to be submitting that he was just dropped by the prosecution.
That was Mr. Edis's closing speech.
Yes.
Is that in Mr. Edis's closing speech?
The prosecution
Yeah, okay.
invited great caution, but still did rely on.
But still did rely on it, yeah.
And I'm sure Justice
Certainly,
Sweeney's right.
certainly the judge directed extreme caution.
As far as that's concerned.
It's in the summing up. Well, it comes from the summing up. It's the
Right at the
the
very end.
Yeah, that's right.
That's right.
it's the summary of the speeches.
Yes,
The
yeah,
summing
yeah.
up, as opposed to the learned judge's comment. One of the reasons of the relevance of the trial date, of course, is that having given evidence on the 30th of November, he was arrested on the 19th of January the following year. The trial was still going on when he was arrested, but it finished on the 28th of January. We'll try over the short adjournment to confirm when he was charged, which is, I think, one of the lady's questions. He pleaded guilty on the 22nd of February. So the formal admission in court was, of course, after the trial had finished. And whether that to which he was accepting he'd done would have, for example, today passed a bad character application going to his honesty. I won't rehearse before this court, but looking at that chronology in any event, we submit that the issues as far as Wainwright are concerned are not sufficient to attack, certainly on their own, the safety of this conviction.
You dispute that they are or were disclosable.
I think there's an argument that they might not have been disclosable. Some may have taken a different view about that. And disclosable to the extent it would alert those defending as to whether or not they had material to make an application, as opposed to conceding that they were admissible.
There is an issue about whether or not the prosecution, in the case of Mr. Park, knew about whether or not there had been prosecution of Mr. Wainwright. I don't think we have any
We've made inquiries.
information about that positively one way or the other.
We've made inquiries and Miss Oakley is proceeding, and we have nothing to suggest that they knew. But I can't, at this moment of time, those inquiries have been made. And of course, had we found a link now, that we would disclose those things to Blaxland. The case officer is in court. Should the court require evidence on oath in relation to knowledge, that could be attended to, and I could have a witness statement taken. If I may move to Dr. Tapp. Firstly, I've not actually physically taken it out, but in case the court wants to see what became Exhibit 1, it is available in court. The court is assisted by the schedule of accounts that Dr. Tapp has given, and the court has the information in relation to the evidence that was available at the inquest and the annotations on the statement in relation to the teeth. Certainly, as far as his evidence at the trial, there doesn't appear to have been any reference to any marks on the teeth. That, of course, comes more significantly at a later point. But at page 19 of our RN, did the prosecution suggest that the wooden-handled ice axe, what became Exhibit 1, could be the murder weapon? And there's no evidence in our submission that it was positively suggested that the wooden-handled ice axe could be the a murder weapon during the trial. Coming up to the trial, the ice axe was listed on the schedule of unused material, and its reference numbers are dealt with, for example, in the correspondence that went to the defence when it was to go off to be seen by an expert. The court will know that the ice axe was not exhibited by the prosecution during the trial, except Mr. Webster had opened a significance of the ice axe. But it only became an exhibit when it was shown to the witness Paul Shaw during cross-examination by Mr. Edis on behalf of the appellant. The notes, as best they've been able to be established now, are that report saying don't think it was an ice axe, and whether Mr. Webster knew or had heard of that. Lady, as we've indicated previously, the record that had been said, we submit should have been disclosed. But there isn't, as Mrs. Justice May pointed out, a statement to the effect that that is what Dr. Tapp had said. And it wasn't in our submission advanced consistently or persistently that Exhibit 1, as it became, was the murder weapon. There was the very obvious difference in description that Wainwright had described to the axe that was produced. I think it's, if not directly accepted, implicitly accepted by Mr. Blaxland that the appellant wouldn't have retained the actual murder weapon had that been what it was, for it to be recovered so much later. But it did, of course, have a significance that it was an ice axe that he did have and was recovered, which is some support for Wainwright. The facts as to whether or not the ice axe could have inflicted injuries, we're not saying necessarily the death, but the injuries or some of them to the deceased's face, remains clear in our submission. Dr. Fagan Earl has written a report which says it is capable of causing the injuries, and Dr. Kohler, as far as we understand his evidence, makes it plain that it was still a candidate for causing some of the injuries. And perhaps just before we break, if it's agreeable to the court, could I just take the court to the statement of Dr. Kohler, the report of Dr. Kohler. It's at divider 33 in bundle 3. Sets out the material provided at internal pagination 10 of 24, bundle pagination 8 through 2. There's, at the very bottom of the page, the cause of the hand injuries, and there is reference to, over the page, paragraph N, could be a defence injury sustained from a trauma-inducing blow, and who gave that opinion, and then the boxer's injury at the bottom of the page. But over to page 12, timing of the facial injuries. Q, last sentence. In themselves, as Dr. Lawler indicates, there's nothing to indicate or even suggest that they were inflicted in life. Our essential facial injuries are definitely inflicted and remain the only definitive inflicted injuries on the body. They are of a type associated with the application of severe force by an implement. There's discussion of the other injuries over to page 13 at T at the top. There's reference to the inhalation of blood when there have been facial injuries, obviously dealing with Dr. Tapp. At X, disfiguring to prevent identification needs discussion. Consideration of this death in 2019 is very different from consideration of the death in 1976. There have been substantial improvements in forensic science over the last 40 years. There is also an increased awareness of forensic science amongst the general population. But then at the bottom, cause of the facial injuries. This is complex given the state and nature of the imagery. In terms of the images I have seen, there is at least one relatively clean and crisp linear edge to the fracturing, suggesting an edged implement was utilised, and that likely had a narrow edge. Pausing there, the next paragraph should have a line put through it, because on receipt of the odontologist's report, his further report says that that paragraph should go. In dealing with what Dr. Fagan-Earl had said, I agree that more than one implement being used cannot be excluded. BB, forensic pathology cannot indicate what implement caused the injuries, if one, and by that I mean it cannot identify the precise implement, nor can it identify the precise group or type of influence. My reading of the material of Dr. Tapp and Dr. Lawler is that they favour a more conventional axe. I agree that this type of implement could easily cause this female's facial injuries. However, as indicated earlier, no interpretation can be made on the zygoma injury as there is no imagery of this area. And then, if I may just deal with the ice axe.
Before you leave that,
yes,
just to going back to page 836.
Yes.
What he's referring to an image. What's ET7?
Teeth.
So that's the teeth. So it's not the zygoma. Zygoma is only referred to in BB.
Yeah.
Yeah.
And at the top of 837,
Yes.
Having reviewed the material relation to views of Doctors Tapp, Lawler and Fagan-Earl, none can exclude the use of the ice axe, albeit none, from my reading, favour it or identify specific features to support it. And at FF, ice axe cannot be excluded pathologically from causing the non-dental visualised injuries. There are no features that must include it. Any object with a linear, likely narrow edge could have caused. This difficulty is commonplace in forensic pathology, and the problem in forensic pathology is that usually a vast array of commonly known objects can cause a profile of injuries. And so, having corrected his statement in the light of the further reports. He has retained those paragraphs. And we say they show, particularly when read in conjunction with Dr. Fieganell's report, which, if I may, I can deal with very briefly after the adjournment, say it could well have been an ISAX as opposed to the ISAX. Just while I have it in mind, I think the only reference is to the ISAX in the summing up dealing with Shaw's evidence, because quite rightly the learned judge identified the question asked in cross-examination was about would the appellant have used that ISAX in this way. That's why that was being referred to as the ISAX, because it was only in relation to the witness who had been asked specifically about it, as opposed to it being used to inflict the injuries. Major, would that be a convenient no?
2 o'clock. Thank you very much.